Guys, the purpose for our meeting this morning is just to touch base with the rental departments sort of across the board. We've been inundated with queries regarding the COVID-19 and the lockdown and how that has affected the sort of contractual relationships between parties, and more specifically with regards to your landlord and your tenant, both in the commercial sense and in the residential sense. Those relationships, how this lockdown is affecting those relationships. And a lot of people would be hearing the terms vis major, acts of God, causes fortuitous,
supervening impossibility of performance.
Those sorts of Latin terms that are being thrown around at the moment. And the purpose for this meeting is just to sort of try and get everyone together from a rental industry as a whole, and just try and bring some clarity and some certainty in this very uncertain time to the rental industry. So with that in mind, I'm going to hand over to my colleague, Wesley Graham, and he's going to kick us off. I hope that everyone can see this PDF file that Liesl has put up on the screen. We're going to sort of try and work our way through that. And then, of course, if anyone does have specific questions that they need that they'd like us to, please feel free to put your questions into the chat space on the side. And between myself, Wesley, and Liesl, we will do our best to try and answer those questions for you. But of course, we do hope that those questions will be answered as we go along. So over to Wes to start with the presentation.
Good morning, everyone. My name is Wesley Graham, and I am an associate in STBB's litigation department in Cape Town. I specialize in rental dispute resolution. So I suppose my function has become very important in these uncertain times, given that parties are still obliged to perform in terms of the various agreements that regulate their respective relationships. So I think let's start on that point. Whilst these are uncertain times, all our relationships, and when I say our relationships, I mean landlord and tenant relationships, are still governed by an agreement. And we mustn't lose sight of that. And your agreements will contain various reciprocal obligations. If you are a landlord, you will be obliged to give occupation to a tenant. And if you are a tenant, you will be obliged to make payments of monthly rental on a date stipulated in the agreement. So insofar as COVID-19 is concerned, and I think Dave can chip in here as well, but I would say that we are of the view that parties are still obliged to comply with their obligations arising from an agreement. And I'm speaking more in terms of a residential lease agreement at this point in time, because 9 times out of 10, your tenant will still be in occupation of the property as it's his or her home. And insofar as that is the case, your lease agreement will in all likelihood contain a clause that stipulates that the rental must be payable monthly in advance without any deduction or set-off whatsoever. So insofar as that is the case, tenant is still obliged to make payment of the monthly rental in accordance with the terms of the agreement on the date as mentioned in the agreement. Dave, I don't know if you want to take over from here and maybe chat a little bit about supervening impossibility of performance and the effect of a force majeure clause contained in an agreement.
Yeah. Okay, great. So just to maybe take it a step back as well, and maybe just to summarize this point, guys, the port of first call when it comes to these very uncertain times is to always start at the contract. The contract between the parties is the governing document between the parties. So whenever there's a question about what someone can and cannot do in terms of that relationship, whether it's a commercial lease, whether it's a residential lease, whether you're buying chips from Pick and Pay, always look at the contract. although you might not be necessarily signing contracts every time you go into Pick and Pay and signing and buying chips. You get the point. So the first port of call is the contract. Now, whether it's a commercial lease or whether it's a residential lease, it shouldn't really matter insofar as the party's obligations to perform in terms of that contract is concerned. However, there are instances and there are situations where some of those contracts might have a vis major clause, and some contracts might not. Obviously, if your contract does have a vis major clause in it, you would need to be guided by what that specific clause says. So, for example, if the specific clause says you will not be released from your obligations in terms of paying rent or in terms of providing the premises or giving occupation, if there is a vis major, then you must be guided by that. And that would be the governing provision of the agreement. If there isn't such a clause in your agreement, you then have to look at the common law and what the common law says about these kinds of situations and whether it's impossible to perform, whether it's not impossible to perform. But perhaps also just taking another step back, for those of you who do know and for those of you who don't know, the current situation in South Africa and globally is that there is this COVID-19 pandemic. If you didn't know about it, you've been living under a rock, but now you do. And COVID-19 is obviously affecting a lot of people in a lot of different ways. One of the ways in which it's affected South Africa in particular is that the president has declared that the country will be on a national lockdown. So just to sort of try and split hairs, really, it's not COVID-19 that's causing the problems in your contractual relationships. If you want to be specific, it's the lockdown that's been implemented as a result of COVID-19. So that's just FYI for your purposes, but it's also a very, very important distinction, because what a vis major is, what an act of God is a standalone fact on its own. Once you've determined whether something is or isn't a vis major, you then have to go further and you have to look at the inquiry as to whether or not that particular vis major or that particular event has made it objectively impossible for you to perform your contractual obligations in terms of the agreement. Wes, I don't know if you want to chat about the supervening impossibility in the space of residential leases.
Yeah, so I think I touched on it very briefly. And, you know, as I said, 9 times out of 10, your tenant is going to be in occupation of the leased premises, the residential lease premises. So therefore, he or she is going to be enjoying that premises, using it, enjoying it. And as a result thereof, he or she needs to perform his or her obligations in terms of the agreement, and that would be making payment of rental to the landlord. Now, I don't know, Dave, do you want to touch on sort of dispute resolution at this point in time?
I think let's get through the general aspects of it, and then we can sort of try and give examples on how disputes are going to be resolved, or how we suggest disputes should be resolved.
Okay. All right. Yeah. So look, I think it's for me, it's an economic point of departure when it comes to residential lease agreements, and they need to be distinguished from commercial lease agreements. And you know, we keep harping on about the point that the residential tenant is in occupation of the premises, which I think is a very important point, because he is using and enjoying that premises. Now, it would be very different for a commercial premises, where, let's say, perhaps the tenant is, he's been stopped from using and enjoying the premises, given the regulations that have been enacted by government. So I think one needs to look at that distinction. I don't really want to say whether or not that the tenant would be, allowed to withhold payment of his or her deposit, because I think that's a whole different discussion. But I think focusing on a residential point of view, if the tenant is in occupation and is using and enjoying the premises, he needs to comply with all of his obligations arising from the agreement. And one of the most pertinent obligations, or the essentiality of the agreement, is for him to make payment of the monthly rental to the landlord.
Yeah. So Wes, I think what we need to also try and establish, and what we need to get through to our audience, is that if someone is going to come along, and these are the questions that are being asked, guys. These are the questions that we're having to field quite a lot of. Is, am I, as a tenant, allowed to stop paying rent in the residential sense? We'll get to the commercial leases in a moment, but am I allowed as a tenant to stop paying rent, or am I allowed to ask for a reduction in the amount of rent that I have to pay because of COVID-19 and or because of the lockdown? Now, that question can only really be answered, guys, in the realm of, one, as we've discussed, by looking at what your contract says. And secondly, if the contract is silent, you have to then ask the question, and I cannot stress this enough. The pertinent question that needs to be asked in answering that question is whether or not either party's performance has become objectively impossible. So in the landlord-tenant scenario, what you need to ask is, from a landlord's perspective, is it objectively impossible for me to provide you the premises so that you can occupy the premises? And then from a tenant's perspective, you have to ask yourself the question, is it objectively impossible for me to rent? Okay. So what is happening is that a lot of people are saying that because of COVID-19 and or because of the lockdown, I have now lost my job. I've had to take a pay cut. My business isn't performing. Now I'm not getting an income, so I can't pay the rental. Guys, from a general perspective and taking a hardline approach to what impossibility of performance is, those kinds of things, I don't think, and Wes agrees with me, and we've had sort of lengthy discussions about this, I don't think that is an impossibility. The fact that it becomes harder or more commercially difficult for a tenant to pay rental is not a ground for impossibility. Impossibility, in the sense of what the law sees it as, is, for example, if my premises burns down, if my building is destroyed as a result of an earthquake, if my roof is blown off as a result of a tornado, if I may not have more than 100 people in my premises at one time, and I am, for example, CTICC, those kinds of instances would be considered as impossibilities of performance. It is impossible to perform. The fact that it is more difficult, or commercially, you can't really afford to pay your rent, that doesn't amount to an impossibility, guys. And this is the very, very, very important thing that we need to ask ourselves. So if the contract is silent, we move on to this next question. And that is the question of impossibility.
Yeah.
And it's tough to say in these times, but it's not going to be impossible. And I use the example of, if COVID-19 wasn't around, or if the lockdown wasn't around, and you lost your job, or a tenant lost their job, or a tenant contracted HIV or TB or cancer or something that made it more difficult for them to pay their rental normally, besides the fact of the lockdown or COVID-19, it would still not be impossible for them to perform. It would be more difficult, but it wouldn't be more impossible. So this is the message that we're trying to get through to people, guys, is that it's that impossibility that will result in the contract sort of falling away, or the contractual obligations of one of the parties being extinguished. And only then can you really talk about whether or not a party has a right to cancel or not. Wes, I don't know if you want to take that further.
Yeah, so I think it would be a good time to maybe talk about dispute resolution at this point in time.
Sure.
So I think that our listeners need to need to be aware that this is a defense. So supervening impossibility of performance or force majeure, it's a defense. It's a defense that one of the parties raises for not being able to comply with his or her obligations in terms of the agreement. And because you as the tenant or the landlord, whichever way, because you are raising this as a defense, you have the onus to prove that defense. So let's use the example of a residential relationship, tenant-landlord. Landlord gives the tenant use and enjoyment of the premises, occupation, and now the tenant must make payment of the monthly rental. But unfortunately, the tenant can't make payment of the monthly rental. So what does the landlord do? The landlord then invokes his rights in terms of the agreement, places the tenant in breach. Tenant then receives a notice of breach. If it's a fixed term contract, 20 days within which to remedy his breach, he then writes to the landlord and says, I cannot perform for whatever reason. You use COVID-19. I've lost my job. I have absolutely no money. I simply cannot pay the rental. The onus is then on the tenant to prove to the landlord that he cannot make payments of the monthly rental. And he will do so by, when the time is right, discovering bank statements, discovering investment statements, that sort of thing, to prove that it is objectively impossible for him to comply with his obligations in terms of the agreement. Now, I need to stress that I'm talking about point number 2, and that is when the agreement is silent as to the force majeure. But we must also remember that there are other clauses in an agreement that will be applicable to this kind of scenario, and we call them the indemnity clauses. So for instance, if the agreement says that you must pay monthly in advance on the first day of each and every month without deduction or set-off, that is very important, because the landlord might say to the tenant, but hang on a second, buddy, in terms of the agreement, you were not entitled to withhold payment of any monthly rental for any reason whatsoever. And that's why it goes back to the first thing that David said, and one must look at the agreement. One must look at the contractual terms of the agreement, because at the end of the day, that is the document that is governing the relationship between the landlord and the tenant. And it's very, very important to remember and to not get caught up in this COVID-19 regulations hype, but remember that your agreement governs the relationship, and that is very, very important.
Yeah. So just basically to summarize what Wes is saying there is that in the real world, what would happen is that you as the agent, you're going to get queries. So someone's going to come along to you and they're going to say, I can't pay my rental this month. And you're going to say, well, that's a problem, because in terms of the contract, you're supposed to pay your rental. And then what happens is, if they don't pay their rental on the first day of the month, whatever the case may be, our suggestion from STBB would then be to say, enforce the contractual provisions. Okay.
Absolutely.
But subject to what we're going to say next about, alternative dispute resolution methods. But you have to enforce those provisions of the contract, guys, because if you don't enforce your provisions of a contract, you're going to start setting a very bad precedent. So our advice would be to send out those letters, send out the breach letters, send out the letters of demand, comply with the terms of the contract. And if the tenant then genuinely does have a problem, and if the tenant really is in a position, it is then, the obligation is then on the tenant to come to you as the managing agent, or to come to the landlord and to say, it is impossible for me to perform. I cannot pay rental. Now, I've already said that our view that we are taking at the moment at STBB from a general perspective is that the lockdown is not going to equal an impossibility. But that's not to say that each case can't be judged on its own merits. So when the tenant does come to the landlord or to the agent and says, I cannot perform in terms of this agreement, the tenant has the onus to prove that. And unless the tenant can prove that, the landlord is not obliged to entertain that any further, and he can simply proceed to enforce the terms of the agreement. The actual enforcement of the agreement at the moment might pose some logistical problems because of the lack of access to courts and the sort of the approach that some of the judges have adopted in not issuing or granting eviction orders during this time. But that's a separate inquiry. You know, there's one inquiry which is enforcing the contractual provisions, and there's another inquiry as to how those contractual provisions are being enforced in court. But that's something that we need to worry about as legal practitioners from your side.
Yeah.
But moving from that point, and I think Wes will be able to touch on this more thoroughly, is the question of, well, you know, now that we've enforced this contract, and you know we're very strict and we're on our high horses, and we're saying, no, the contract says you must do A, B, and C. What does that actually mean for the long term? Are you actually really genuinely going to kick this tenant out, or are you going to try and come to some sort of arrangement with your tenant? And I think Wes has got some good examples on how in practice he's dealt with this. So I'm going to let Wes talk about the alternative dispute resolutions that we've sort of encountered in this period.
Yeah, thanks, Dave. Look, I think landlords need to remember that there's a symbiotic link between themselves on the one hand and the tenants on the other hand. You know, I'm going to quote our president here. This thing will blow over. We know this. It's going to blow over. We don't know exactly when, but we do know that it's going to pass. And when it passes, you still want your tenant to be in occupation of your premises. We know that the market isn't great at the moment. The market wasn't great prior to COVID-19. So a lot of landlords are sitting with open premises, and it's very difficult to find a good paying tenant. That being said, I am of the view that we shouldn't act on impulse, and we should be all making sound commercial decisions in the circumstances. So that being said, we've spoken about the enforceability of a contract, and I think it's important to do that. But at the same time, I also think it's important to start negotiating compromises on a without prejudice basis, which means off the record, without prejudice to any of your rights in terms of the agreement, with your tenant. And I say this because when this thing passes, you still want your tenant in occupation. That is your security. The security is your monthly passive income that you're receiving from your tenant to service your loan. And you need to make sure that your tenant is happy. So that being said, I'm going to talk to you about one practical way to deal with the situation. And it's you know, it's something that we've put into practice very recently. What we did with another client was we said to the tenants, we said, right, we understand that you guys are not working at the moment and that income may be an issue. So what we will do is we will negotiate a reduced monthly rental for a period of 3 months, okay? That's the first thing. So talk about a fair and equitable amount of rental that the tenant needs to pay to the landlord for that period of time. Then secondly, we said to the tenants, if you're unable to pay the reduced monthly rental, what we will do is we will apply a portion of your deposit to the reduced monthly rental for the period of 3 months to extinguish, you know, any sort of debt toward the landlord. And thereafter, upon expiry of the 3-month period, we will reinstate the original rental amount that was decided upon before COVID-19. And you as the tenant will be liable to make payment of a monthly top-up to reinstate the deposit. Because remember, your landlord's security is his or her deposit that he holds on behalf of the tenant for any damages or any amounts owing to him or her when the agreement expires. And that's been working really well. Tenants have been very grateful that, you know, we would allow the opportunity for the landlord to utilize the deposit or a portion thereof to pay off the reduced monthly rental on the proviso that they will reinstate that deposit upon expiry of the 3-month period. And everybody's happy. The tenants are making payments in accordance with their contractual obligations. The landlords are still receiving an income. And upon expiry of the 3-month period, the contract will revert to or the status quo will revert, and the contractual arrangement will continue as if COVID-19 didn't happen. Look, I understand that it's very difficult to decide how long this thing is going to be around for, but at this point in time, and given the experience of China, it does look like 3-month period is reasonable in the circumstances.
Good, thanks, Wes. So yeah, guys, I think in summary, you just need to understand that there's the strict contractual approach that your landlords can take, and those are your rights. So I think the first port of call might be to advise your landlords and to say, look, these are your rights in terms of the contract. This is what you're allowed to do, but from a commercial perspective, these are also options, and maybe just try and sort of guide them through this process, just to think about the long-term effects of the continued occupancy of their premises. Guys, we are running short of time, so I'm just going to speed through these things. I see that Dylan also did raise a question that I just want to touch on there. But very importantly, guys, I think from a relationship perspective and from a contractual perspective, something that you guys need to be aware of is that if your tenants try to raise the lockdown or COVID-19 as an impossibility to perform, the legal ramifications of saying something like that, and this is why impossibility is such an important aspect that you need to consider, is that if it is found that a party is prevented from performing because of an impossibility, what that means in law is that that contract must come to an end. So there's no negotiating after there's an impossibility. If someone has found to be impossible for them to perform, the legal ramifications of that is that contract terminates. Because someone can't perform, your obligations are extinguished. It's done. It's finished. Goodbye. So that is why I'm saying you should be very slow to accept something as being impossible to perform, because as soon as that is accepted, that contract must be thrown out the window.
Done.
The obligations are extinguished.
Yeah.
And that's why I'm saying I don't think that the lockdown is going to result in an impossibility. I think it's going to result in a difficulty, but not an impossibility. Yeah. And if it's a difficulty, then perhaps, as Wes has mentioned, there's a couple of alternatives that landlords can look at this stage. And I think that's where we need to be heading. I mean, we're all in this together, and we should be pulling together to try and make this work for everyone. So,
Dave, sorry. I just want to touch on the impact of the Rental Housing Act and the CPA very quickly, because I think it's pertinent. All right, guys. So my 2 examples. If your landlord instructs you to place your the tenant in breach because he hasn't made payment in accordance with the terms of the agreement, please remember that if it's a fixed term agreement, Section 14 of the CPA is still applicable, and you must, as the landlord, provide the tenant with 20 business days within which to remedy that breach. Upon expiry of that 20 business day period, the landlord may either elect to cancel the agreement or to enforce specific performance of the obligations. All right. So please don't forget about Section 14 of the CPA. It's still applicable in these circumstances. Now, secondly, if your landlord agrees to a compromise with the tenant, it's very, very important for you as the managing agents to send the tenant a monthly recon. The Rental Housing Act says if you guys debit any amount from the deposit, you need to inform the tenant of that debit. So you need to be sending monthly statements. I know that all of you guys do it and you comply with the act, and we're very grateful for that because it makes our lives a lot easier when we have to litigate. But it's very, very important that if you guys are debiting anything from a tenant's deposit, that you are making the tenant and the landlord aware of that debit, and there's obviously a corresponding credit. And the landlord and the tenant need to be able to see the debit and the credit, as well as the amounts applied to the monthly rental. So please, guys, do not forget to still comply with your obligations in terms of those 2 pieces of legislation. It's very important.
So quickly, guys, just to touch on the 2 questions that have been raised, Dylan. in my opinion, I don't think that the lockdown is going to cause an impossibility to your guest house. Remember that the obligation, if I'm renting you a piece of land, your obligation is to pay me my rental. The fact that it becomes more difficult for me to pay my rental is not an impossibility. So in that scenario where, let's just hear what you say here, where the property is being rented as a guest house, I presume that the landlord is the landowner, and he is renting it to a tenant who is running a guest house on that premises. Now, I'm sympathetic that the tenant will not be able to conduct his business from the premises, but conducting the business and paying the rent are two separate obligations. Unless your agreement specifically says that if I can't conduct my business, then I will be released from my obligation to pay. And unless there's a vis maior clause in the particular agreement, I don't think that is going to result in impossibility. The second question from Boss J, Wes, if you can quickly just touch on that. We've got 2.5 minutes left.
Yeah, sure. So look, the Rental Housing Act says that upon expiry of a lease agreement, the landlord is entitled to apply the deposit to any amount due and owing to the landlord. So that's the first thing that we need to remember. And secondly, the Rental Housing Act says that the deposit belongs to the tenant and that it must be invested for his or her benefit. But there's nothing stopping the landlord and the tenant from concluding an addendum to the agreement in terms of which the tenant elects to allow the landlord to apply a portion of the deposit to the reduced rental amount. As long as it's in writing and signed by both parties, I don't see there being any issues there. And I'm sure Dave agrees with me.
Yeah, I agree with you. As long as there's consensus between the parties, I don't see an issue. Christine, your question, this is a question that's come up a lot. Until legislation, or until there's a regulation that says the contrary, I don't think that the 20 business days, the business days are going to be affected. I think that your contracts have a specific determination of what a business day is. So that's a contractual provision. That's an agreement between the parties that they've agreed that these will be business days. And secondly, these are business days. We are working. The president has encouraged everyone to work from home as much as possible. So until there's a regulation that says to the contrary, I'm of the view that these are business days. 1 minute left, guys. Just quickly, if we don't get your questions, we'll ask Michelle just to note the questions and we'll try and get back to you as quickly as possible. Just remember with commercial lease agreements, guys, there are issues where this comes up in commercial lease agreements. We might have to deal with that in a different session, but basically, sure, yeah, we are running out of time, guys. I am going to have to deal with that in a separate session. Guys, from our perspective, from STB's perspective, thank you very much for joining us in the session. More than happy to do a follow-up session for everyone later next week, whenever you want. We're here, we're available for you. And if you have any questions, please direct them to Michelle and she'll forward them on to us. So thanks very much, guys.
Alternatively, you can email David and I. Our emails are bottom left of the screen.
Yeah. So we are going to be cut off soon. Thanks very much, guys. Hope to see you soon.